as far as I can see, and I'm not in your position, flag everything they think that you want to hear about and give you the opportunity to address it on your own. And that is part of the delegation structure. So nothing prevents the board from withdrawing a delegation back up to yourselves where it's been given. This is just, this approach is balancing the amount of time it would take for the board members, your time and everybody else's time, to hear each and every one of these issues, when you might want to focus on batches of issues that are of larger significance or statewide significance, as opposed to you know, a diverter A versus diverter B complaint that is more run-of-the-mill. So, I mean, I think that the goal is to keep this as consistent with the usual delegation process as possible.
So I have, I'm trying to piece together the additional information, the 7 days, and how that might play into the petition for reconsideration and the resolution language that directs the Division of Water Rights to suspend an order in the event that you see a problem. So picturing a diverter that's out there that receives this additional information, if we're talking about post, they've already received information under a notice, and in fact they have received not just the notice of the notice, but the actual notice. Okay, so now they're going to get another shot at it. And let's say they, and I'm not quite sure, so the information in that 7-day period, that's this additional, more granular information. We're going to call it the Valerie Kincaid, Tim O'Laughlin suggestion that you've got, okay? So there would be some additional information that a diverter would have at this point. Let's say they try to get a hold of you to clarify something or to point out an error of some type. Hopefully, they're going to get to you and you're going to be able to respond or fix it. In the event that you don't, that additional layer exists with the petition for reconsideration, kind of newly configured with you better look at it quickly, 30 days or prior, and if you see a problem, you've got to suspend right away.
That's right. These are not exclusive methods for reviewing the information and suspending curtailments if something is incorrect. These are cumulative that everybody could avail themselves of at each stage of the process or ongoing. The only thing I want to point out is, as it's crafted right now, unless we change it, the 7-day additional notice wouldn't apply to the post-14s. So somebody who's gotten a notice of a notice and then a notice, they wouldn't get this extra notice. They're on notice.
Right.
As proposed.
Or we may want to modify that, especially if we adopt today. The idea is to move quickly, especially on the post. So maybe we would want to still require that information go out, but just modify the number of days.
We could certainly do that. I mean,
You have the information? You'd be able to put it together? The information that would be, whether it's 7 days or whatever it is, you have that information readily available?
I think since,
on the
in
post.
some ways, shortening that to 5 days or something would make even more sense, because this information gets updated. I mean, so argument could be made both ways, but shortening it, the longer you put it out, the longer then conditions change, and then you would end up just kind of chasing a data point. So something a little bit tighter, 5 days could actually be.
Well, I'm thinking on option B.
Mm-hmm.
Not on option A, but on option B, that it'd be helpful to have the information out under option B as well. But I don't know that it needs to be 7 days necessarily.
All right. Keep going. We'll come back. Thank you.
So then I think the last point on the change sheet before we get into the Route 2 or Route 3, Path 2, Path 3, there's probably should have used 2 or 3 on here, but we already had it numbered. But it is the no precedent language that was requested by a number of commenters. So what we've proposed, and we're looking at paragraph 5 of change sheet 2 right now, is putting language in the therefore be it resolved section of the resolution that says, except for purposes of enforcement of a curtailment order issued pursuant to this regulation and any curtailment order issued hereunder should not be cited or relied upon as authority for or evidence of any water right affected or protected by this regulation. The concern that was most raised about precedent was that the information we use in issuing curtailments would then be applied wholesale forevermore
Right.
as evidence of somebody's right when we really think we know it well enough, but if we don't, the curtailment could still have been correctly issued in a batch. So let's say there's no water available for anybody whose right post dates 1900, and we have incorrect information saying somebody's right is 1910 and really it's 1905. That doesn't change whether the curtailment was correctly issued, but I understand why people wouldn't want that evidence. It's not even evidence. Why our conclusion that their right was such to be used again in a different proceeding. So that's what this is
Not
designed
in
to
an
address.
emergency situation. Right. Okay.
And unless there's other questions, we could go into the 2 different options.
Yeah,
which-
let's take a little time there. Can you give us a minute to actually read it before you start?
I don't want to interrupt your reading, but just so you know, paragraph C that's under both options A and B are the same. So once you've read it once, it applies to both.
Right. So the theory here is, so this says in A, in general, this was Tom's sort of, what was B yesterday, is to say that we would do curtailments. Let me see if I understand this. We would do curtailments under the normal process. We could. There's nothing that would stop us from doing it under the normal process. But you all would be able to invoke this section if there was a complaint or we made a determination that the stored water was at risk of unlawful diversion. So it's kind of a, you can only use this if you can't use it on your own volition. It's a little complicated.
Essentially, Tom had styled option 2 as including pre-14s and riparians, but targeted. And so this is the target. So post-14s, the regulation would apply as we've discussed yesterday and today. For pre-14s or riparians, the curtailment order could be issued under the regulation under scenarios 1 or 2 here, which is if there's information that the deputy director has that stored water is being unlawfully diverted by those diverters, riparian or pre-14, or if there's a complaint filed by another legal user of water. Not any complaint, but a complaint by another legal user of water. We're not trying to make this into something that it wasn't before we started talking about it yesterday.
So in essence, you would be able to deal with pre-14s and riparians under both scenarios.
We would always have the existing pathway available, but if a large portion of the questioning of the justification was where are these complaints about diversions by people who shouldn't be diverting our water, well, if those complaints come in, it seems like the justification for the reg, with or without pre-14s, is that you need to be able to move nimbly to address that situation so water gets where it's going. And so these 2 triggers make it such that you could use the process outlined under the reg. Everybody else, every other pre-14 or post-14, if they're to be dealt with by curtailments, would be dealt with under the existing process. And whenever you'd like me to, I could discuss paragraph C, which, as I just mentioned, is the same for both option A or B as proposed, and that has an additional reporting requirement. So whether you're in option A or B, which reflects option 2 or option 3, as Tom described them yesterday, it seems as though there is a paucity of information about some of these rights, and there was a desire that I heard to address that. This is also limited to address curtailment issues. This is not reporting for reporting's sake or trying to get information from riparians and pre-14s just
On
because we
everything.
want it.
Okay.
The limitation is if there's a complaint, it's essentially the same limitations as in 1 or 2 in option A. If we receive that type of information, then the deputy director could issue an enforceable order under the reg. So not a curtailment order, but an enforceable reporting order that would carry the penalties we've already discussed,
To expedite figuring it out.
asking for this type of information.
Right, and then the resolution language is just explaining the intent.
Right, if you're adopting, the initially proposed resolution was reflecting one regulation, and if a different one is adopted, then this would be explanation in the resolution for that.
Okay. And so option B limits the regulations to post-14s, but adds this information gathering ability.
Correct. Paragraph
that
C
is
would
what we
apply the same. So
Okay.
under under 7A, which was the option 2, sorry about that, we've got the 2 points, 1 and 2, under which a curtailment order could be issued. Option B, for the most part, takes that same information, but a curtailment order couldn't be issued on that information, but the additional reporting could be required based on that additional information.
And a curtailment notice could still be issued to, under option B for riparians and pre-14. So we still have our normal curtailment process, our existing curtailment process available in that option as well.
So on
Right.
that point, I thought yesterday when we were looking at option A was, I think, 2, option B, 3. There was, Mr. Howard made some comment about targeted actions under, I think, classic curtailment, under option B. So might we consider some resolution language along those lines under option B? And I'm looking at the language that you have under option A, G with 1 and 2 as possible resolution language for classic curtailment or the, normal process.
You would want to say that has to be targeted as well? Is that
Well,
what you're saying?
in other words, some
That-
resolution language indicating the board's interest in having staff, if you do receive a complaint and you go through the reporting process, you get the information and you've determined that stored water is being unlawfully diverted. I would include transfer water. I guess, I don't know if it's already
Yeah, no,
encompassed,
that's
but
a good
yeah.
clarification.
yeah. And another legal user has filed a complaint. Now you have, the reporting, some additional information to determine whether or not you could go ahead, that we would, direct staff to focus efforts under the normal curtailment process in those areas.
Yes, we could develop resolution language to that effect.
So to encourage that, not to constrain them.
Right. Yeah. encourage staff to move in that direction,
Right,
and
so
also
prioritize,
as a way to,
curtailments of pre-14s and riparians under our existing authority, based on a complaint or information that indicates that stored water or transferred water is being illegally diverted.
right, so
Yeah, we can.
full-blown process under current, authority that we have, and also using it as a way to kind of give the stakeholders or the users a heads up.
I'm sorry, I was just rereading. Other questions?
I think you all did I think you did an amazing job so quickly.
My only, I guess, additional request is, and this would probably go into the the resolution rather than the regulations, is identification of some kind of a process for going forward to obtain more information, to work with the water right holders in identifying and improvements to this process should we face the same situation next year and looking at potential curtailment. I want us to be in a better position with more informed and engaged water right holders and more prepared in terms of whatever action that the board might consider next year.
I'm glad you brought that up. I actually, I received, I'd like to get this out to others. I received some language from David Guy
Yeah, I think it
on that.
came out to
I
all
think
of
we
us
all-
as a
Oh,
late
okay.
comment, but that's worth thinking about.
That is also posted on our website,
Okay,
the David Guy document from Tam that was sent.
Yeah.
okay.
Don't you like being the David Guide document, David?
We just received that as well, and if you'd like that in the resolution, I'm sure we
Mhm.
could
Yeah, I'm just want to
modify
I
give you an
would like
opportunity to
a-
say, what do you think about it?
think I would
Seems
like
like a
a
good idea.
A modified version of that, rather than, not that I don't appreciate the attempt, Mr. David Guy. I think the substance, the spirit, which which is expressed in what he recommended, I would agree with. I think, however, such a process need to perhaps be a little bit more flexible and not, I mean, we can't be too specific at this point in terms of what sort of things the group might want to look at and what sort of shape, form the discussions might be held in. So I would, I guess, look to Mr. Laufer, because he is the master wordsman among us all, to suggest some language for the resolution that captures the spirit of what I'm recommending and what Mr. Guy has provided without being as specific.
I'd be happy to do that. We actually have already done a little bit of playing with the language, and I think Ms. Turgovich may have the modified document, and hopefully we can put it up in a moment.
All right. While she's doing that, can we go back then to a couple of things I want to talk about? Obviously, we do have to have the A, B, or other mega conversation as well. Again, I actually appreciate the limiting the time for petitions, and I'm looking at this side by side that Ms. Zalesi gave us yesterday. And help me think this through, because I'm trying to think through this issue of the perfect being the enemy of the of the good. And I think to a certain extent this may, because there is difference in experience and how far we've gone in the pre-14 and post-14 worlds, which are different in some ways and not as different as people would think in others, but definitely different in some significant ways. I'm trying to figure out in this process how we get to a confidence level that folks have had the chance to say we're wrong, where we've looked at the kind of the factual base. So we normally have a reg. When we do a reg, we have authority to impose fines or whatever we do for violating a reg. That's not an unusual construct. But generally, before we do a reg, we've had a bunch of hearings about the actual basis for the regs, the situation in which they would apply. In this case, we're going to be doing curtailments, and there may be a time where someone does not get any time in front of us to challenge whether that factual circumstance was correct, other than at this meta level or working with staff. And that it's not totally unlike some of the appeals of decisions that Tom or others make on 401 matters or whatever. We don't take every petition for reconsideration either from a regional board or a cert, and generally you flag for us if there's a controversy and somehow you poll us, because we can only meet together when we're in public session, to see whether there's an appetite to bring it up. So, and I'm not suggesting, because it would defeat the purpose, that we should have individual hearings on every factual circumstance where someone disagrees with staff if we're going to make this work. But I'm trying to figure out how to deal with the ability for folks to challenge the assumptions adequately. I know that becomes more pointed with the pre-14s because there's more historical and other practice at stake. So I'm trying to figure out if my suggestion off the top of my head of you giving us a review more formally once a week of what's coming in the nature is enough for us to be able to flag those things on which we might want to do a public hearing on a circumstance, or to give you that feedback that, yeah, this is a petition we're going to want to hear. That's what I'm trying to struggle with, because it's still, if you look at this chart, the 30 days is helpful, but you still have the opportunity for the 30 days to run and nothing happens for the person. So the issue is trying to figure out when to flag a significant issue, which is, it's not that I don't trust your judgment on doing that, because my experience just in the 2 years I've been here is that you and your colleagues haven't missed a beat yet and have erred on the side of flagging things. That doesn't necessarily make the people out there feel better. So help me think that through a little bit.
Well, so there are a couple different...
I know it's not unprecedented, so I'm not saying it's legally wrong. I'm just trying to figure
Sure.
out in the, again, relationship and comfort mode, if we, and we haven't decided whether we, but if we were to apply this to pre-14s.
You know, so first of all, let me be clear. In terms of how I look at this issue, I don't think this is something that would necessarily need to be in the regulation itself. I mean, the regulation already acknowledges, especially with the change sheet, that there's going to be this expedited triage work to identify clear error. But in the resolution, for example, or even in the motion, it's up to the board as to how it would want to proceed. We could set up a process where, you know, it's the obligation of the Office of Chief Counsel or the Division of Water Rights working together to at least provide weekly summary reports to the Executive Director that could be provided to you all of the number and, you know, unfortunately, you know, it's very difficult at this point to gauge, you know, just how many petitions for reconsideration there might be. It's certainly not going to be the thousands upon thousands, and especially if things are
and the more information
down.
you put out up
But
front, the less
it could be a
will
fairly granular or a fairly high-level weekly report. Another tool that would be available is there are 5 of you. I know that there is a desire to have the entire board hear every one of these issues.
No, we
and
can be
that's-
hearing officers, of
But
course.
one possibility is, you know, to have the board members engaged at the staff on the triage work as well. It wouldn't be a hearing. It would essentially be that, you know, individual board members could sit down with batches and the staff to help go through those issues, to help identify which ones, hey, these are key issues that should be going to the entire board. That can be done in a way that's consistent with due process. It's not an evidentiary hearing, but it ensures that board members are engaged, at least in the initial triage work. That's obviously a fairly significant time commitment for you all. Another possibility, instead of batching them, would be to have a board member assisting staff in that sort of triage work and engage, so that at least for the water right holders, there is some comfort that at least one of you all is engaged in some of the decision-making process. And again, it can be done in a way that's consistent with due process. It's part of a reconsideration process that the board members could ultimately be involved in. So that's sort of a middle check on it.
In addition to people being able to come to the drought update,
Sure.
which is.
And I would expect, you are going to see, you have already heard repeatedly under our existing drought process, or our existing curtailment process, regular updates. No doubt, if the board were to adopt this regulation and curtailment orders were to go out under it, that would be a significant component of subsequent drought updates.
All right, now talk to me about, unless there are other, talk to me about A versus B a little bit. Because that then has you proceeding on potentially on two tracks, unless you're saying you're only going to do pre-14 or riparian curtailments if you have a complaint or you see a problem with stored or transfer water. I mean, which is a valid choice to make. I just really want to understand whether you're suggesting going on two tracks or suggesting that would be the track.
My understanding is under track A, staff would pursue pre-1914 and riparians, at least under Ms. Diodamo's suggestion, when there is a complaint filed or a determination made using the rulemaking that the board is considering. And under option B, they would do so using the current process, not under the emergency regulation.
Can I just clarify? I
Yeah.
understood Ms. Diodama saying that we wouldn't be constrained, however, that
Right.
that
Yes.
would be
Constrained
prioritized,
in-
but not a constraint.
Yes, in both.
Under B, it's
just,
is resolution.
yes,
It would be resolution language.
but it's just how you do it. Option A would be under the emergency regulations, and option B would be under the current process.
That's correct. And I was trying to figure out if Ms. Marcus had a specific issue she was trying to get at in terms of the distinctions between those two, other than that high-level distinction.
Well, I'm just trying to be clear and trying to think through again, we're trying to be expeditious in fulfilling our responsibilities, but with our eye, not blindly, but with our eye on impact in the field to legal users of water of various kinds. And so it's not as if you all want to go out and curtail for the fun of curtailment. The issue is, I know you've never done anything more fun in your whole life. No, it's really a question of trying, again, as I said at the opening, to fulfill our responsibilities under the law, mindful of the law, but also mindful of the very real world impact that some of the arguments people make, which are totally entitled to make based on their interests, are easier to make when you don't have to hold the whole and the real world application of the whole, which is what we have to do. So I'm just trying to figure in the option A, you're potentially proceeding on two different tracks with pre-14 and riparians, conceivably, if you found, based on your own calculation of the water, because somebody didn't actually complain, that there was a need. I'm just trying to figure out the real world impact of A.
The information would be the same that we'd be relying on, so I don't think that a complaint is going to necessarily change the information that we're relying on, but the options under A are to go through the different process at the different speed that we've talked about
So
quite a bit.
because someone's complaining or because we see a real issue, we would want to be able to use the speedier process. That's the basic argument.
As Tom outlined the options yesterday, our path 2, which is reflected in A here, was including pre-14s and riparians, but targeted. And so the targets here are addressed to the scenarios that people said didn't exist in their comments. And why is the board doing this for pre-14s and riparians
If we don't
if there
need
are no
to.
complaints or nobody's taking the stored water? And so instead of, well, that seemed like a good target, because that was what people raised as what was potentially lacking. So where it is present, I don't imagine that they would now stand up and say this is the right thing to do, but the things that they identified as not being present would be present.
Right, and so the
Yeah.
difference would be that you could, in the former, it would be a limitation on whether you could act. And in the latter, in option B, it's a direction to prioritize under the traditional system for somewhat the same reason.
Yes, with Board Member Diodamo's additional language saying any reporting, as I understood it, any reporting you get back from somebody where there's a complaint, that the division would investigate and potentially pursue enforcement. I mean, I think that in as much as I'm not on the enforcement side of things, if you wanted to talk to somebody from the Office of Enforcement, they might be able to tell you what they feel about prioritizing enforcement based on information received in response to complaints, but there's a range of whether, in response to your comment, whether that information is considered and the board should consider pursuing enforcement based on that, or investigations
curtailment,
based on that,
not
or curtailment under the
curtailment.
existing process, or
Right.
whether they should actually prioritize that scenario. So there's the difference between how the Office of Enforcement and the division would prioritize just because they receive a complaint versus there's a watershed that is or is not covered by the regulation that has some other priority type issues but wouldn't be covered under this type of situation. So that's a prioritization issue, and if you want to hear from the Office of Enforcement, I bet they could.
Yeah, I
tell you
wasn't
that-
thinking about it that way. I mean,
Okay.
I understand why you're answering that way, but that wasn't really what
Okay.
I was getting at.
Sorry then.
But
No, it's
I think, from my perspective anyway, we should be open. I'm not interested in tying staff's hands on this. So whether that's prioritizing enforcement, maybe directing the water master, especially if there are these delta issues. I don't know what the best approach is, but just to, in the event that we do something under existing authorities, that staff be directed to look at the conditions under G.
So even though I misunderstood Chair Marcus a minute ago, I think I understood you correctly. And as my off-the-cuff drafting of something along your lines was encouraging investigation of whether curtailments under the existing process should be pursued under, in response to the information received. So that would be the board encouraging the division to investigate those issues where we receive the information as opposed to prioritizing. So I think maybe I understood you correctly on that one.
Right, but then maybe expand it, I don't know, curtailment, enforcement, just to include
curtailment
all
under
the
the
options, yeah.
Traditional.
Thank you. We'll do that.
I have,
And, oh, I'm sorry, and not just Office of Enforcement, but Water Master, Division of Water Rights, I haven't been around long enough to recognize, but just
Right. Not a
the full
limitation
gamut.
is what you're talking about. You're talking about address these, focus on these. It's not targeted in the same way that A is targeted, but do something with the information that we have asked for, and that's certainly the intention.
Well, and we're saying we're going to ask for it in the case of a complaint anyway, so it's the question of how you would focus it. I mean, I think the issue is how to, even in the existing curtailment arena where we've got zillions of notices that have now gone out to people in every corner of a giant watershed, that they're at risk, when that might not be where we're going to curtail. So we have this universe of people who are worried and scared, which may well not be the people that we ultimately need to curtail. And again, in an abundance of caution and sending out notice and trying to be fair. I mean, you can't win on this one. It's sort of you send out the notice, because you want to give people notice. But then you get dinged for sending out notice broader than when you're going to curtail. And again, farmers and others who use water end up being in this judgment place that we can't relieve them of that challenge completely. Many people have dealt with it by looking at the fact that it's a drought and planning ahead. Other people on the bubble, or maybe less versed in this or whatever, are being shocked at it for the first time, which I know surprises some, but in some ways we're going deeper. Again, we're going to have to go deeper. You know, a lot of people who are currently at working management, et cetera, age were in school and not doing this stuff in 1977 when we did it before. There are some people who remember the last time, you know, many from seeing it in the newspaper, but not actually having to live it. So it's not completely confusing or surprising that folks that are pre-14s and riparians, who we always feel should know exactly what their rights are, might be concerned. And then everybody reacts to this sort of thing differently based on their view of government or their view of the law or what their lawyer tells them or what they think it should be versus, you know, we who live in it think everybody should know what we know. And so it's just a little bit different. I think the more junior you are, the more you know your water rights and its interruptibility. Maybe not exclusively, but generally I suspect that that's true.
I think everybody agreed yesterday that implementing this would involve, would be very complex.
Mm-hmm.
And at least with the change sheets that we have, we were leaning towards the positives of providing the additional notice to people.
Mm-hmm.
Yes, there are some negatives to noticing things you may not do, but I think people would be, I can't speak for everybody, but in general, the tenor of the comments we heard is that people would rather have the notice and the information. So that was our intent is, yeah.
I know the intent is good, and if we send something out that says we're prioritizing where there's a complaint or I think that will help people, and opposed to the situation where folks are, you know, people want to comply in general with with what they're asked to do. And so people want, I think people basically want to comply with what they're asked to do, but they want to understand it and they want it to be fair.
Just
well-
briefly, Chair Marcus,
Yeah.
for the sake of simplicity on option A,
Yeah, I was going to ask you to actually,
I would take
Talk about it a little
out
bit.
number 2 because that actually opens up the door to everybody in the basin. It basically says target everyone in the basin. And so, and I assume that's not what the Water Board has in mind. Now, in order to address the issue of stored water of the projects and the drought operations plan issue that I raised, we could go to option 1 and say if the projects feel that their drought operations plan is being jeopardized, they're perfectly free under option 1 to come and say, well, we have a complaint that our stored water is being taken. But, you know, I mean, I don't know if...
what about the transfer issue?
Well, again...
Same thing?
Yeah, I mean, if the projects are concerned that their transfer water is being taken, then, you know, again, number 1 raises that same...
Oh,
opens
they-
any window for the projects to say, there's a problem. It's just if we leave in number 2, there is no targeting. That's everybody, because that's what's going on. That's what fundamentally we're doing by curtailing folks, is protecting the stored water that's being taken. So if you leave that term in, you're basically, there is no targeting.
I
Well,
know we've,
that doesn't even get to the issue of what the basic question, I'm sorry, about, which is a judgment call, as all of this is, about how to handle pre-14s and riparians
oh,
in
yeah,
any
I'm-
scenario. And I appreciate the intent of trying to narrow and focus those that might have the expedited process. It still doesn't answer, and this isn't a judgment, not in any way, but just the question sort of raised from a social, anthropological, I don't know, not necessarily legal standpoint of pre-14s and riparians being somewhat newer or less frequent in engaging with us on regulation, curtailment, et cetera. Though I think we have the total right. I mean, we're on record as feeling we have the right. That's quite different from how people feel, because it's relatively new to some, largely because issues are just starting to be litigated or have been litigated in relative recent past, even the '09 legislation is relatively recent in terms of its application. And so it's a readiness or a comfort level. And I'm trying to struggle with, intellectually I can understand why going faster in a case where we've got a problem is something that we want, but I'm still struggling with how you bring people into the tent of how this system works, short of doing a full-on adjudication over 20 years. And so I just think there's a judgment call to be made of and it's a hard judgment call, about balancing the need to act when someone's really is injured, and they're injured by a pre-14 or a riparian, and the comfort level used to it, full-on discussion about how to deal with pre-14s and riparians that we haven't, been through yet. So it's more of a social, cultural judgment call rather than a legal call.
Maybe I'm not being clear. I wasn't opining on option A versus B. I was only saying
You were
that
just saying limit A
option
or
A
B?
should be limited to one, because otherwise there is no targeting. This opens it up to everyone.
Yeah. In other words, the concept of protecting stored or transferred water could be raised in a complaint.
Sure.
And so, in essence, the 1 and 2 distinction isn't necessarily that useful.
Yeah, actually, it's a little more complicated than that. All
Really?
I'm trying to say is that if you leave number 2 in, you're basically saying that the deputy director doesn't have to target at all because they can curtail anyone. Because that's what is fundamentally the problem in the system as presently configured. And so I'm just suggesting that if you want to do option A, that you only want to identify number 1 as the condition that would be used to target. Again, not opining at all on option A versus option B at this juncture.
Thoughts?
Yeah. Transfers. What about the cooling effect that's going on with transfers, which I hear is happening in certain instances? So do we have to have a situation where they allege interference, that the interference is actually occurring? Or can we protect the movement of water in a situation where someone complains saying, I suspect that when I release this, when we get this water moving down the system, it will be interfered. That interference has not yet occurred.
Well, once more, if we're going to get into that issue, that opens up very broad-based curtailments, because what's going on is that depletions in the system are larger than anticipated.
Mm-hmm.
And the reason they're larger than anticipated is that there are in excess of what is necessary to serve the contracts that the projects have. And so, if someone's going to raise that issue and say, well, we want to protect this transfer water, then that really opens the board up to broad-based curtailments to any post-1914 or riparian that is not a contractor. And so I don't see a way to effectively target to achieve
Well,
that.
we've kind of gone round and around, but I'm still not understanding. So if a complaint comes in, and the way to protect the stored water is to look at what's going on in the delta and determine that there is, especially in a year like this, it should be easier to do the math, that if Central and South Delta, and I see my friends there from Central and South Delta, so maybe, they have a differing view, but if our longstanding policy is that they do not have rights to Sacramento River water, that a targeted curtailment could be issued, the effect of which could very well be that Central and South Delta diverters now come in and complain that there are pre-1914 water users on the watershed, and that they would like them to curtail because now they've been curtailed in the delta, sort of the domino effect.
Just another.
I'm not sure what the question is.
Well, I'm saying that I don't see that necessarily we have to open up the entire delta and impact all pre-1914s on the San Joaquin and Sacramento watersheds in doing so.
No, it's true. I assume that there'd be no reason to curtail people on the San Joaquin in order, if there were transfers that were going on from the
Okay.
Sacramento Basin.
All right.
But I guess fundamentally, when I hear you describing that particular issue, it doesn't seem like one so much as curtailment as it is the traditional unauthorized diversion. I mean, if you're stealing, it's possible to be stealing transferred water without it being, without you being in a situation where you're curtailed. And I think the scenario you're trying to address is probably better addressed through a traditional water rights enforcement tool and not just through the curtailment
Which
process.
is, yes, under option B, which is why I'm more comfortable with that approach anyway,
Yeah,
with
and-
the resolution language.
And it wouldn't even just be under option B. I mean, it would be a tool that would be available regardless of whether or not the board adopted a regulation that tracks option A or tracks option B. It truly is, I think, much more of a traditional water rights enforcement vehicle, not necessarily tied solely to the concept of curtailment.
Okay.
Okay. Well, it's an interesting question, which is just the trying to weigh the ability for speed with the doing something that at least feels, I'm not saying it feels more novel to a pre-14 and riparian, and the amount of time we're going to spend on the difference in process versus getting the curtailments done. And I don't know how to weigh that time frame and the importance of speed that you talk about theoretically, because I don't have the same sense of time, because we're still going to have to spend a lot of time on the curtailment reg approach, and even more time in the context of a pre-14 or riparian than with a post-14. So I'm just not sure when you're weighing the balancing of speed. I know it would be, it's easier for me to go with B. So I guess what I'm trying to say is that I need a little more of a reason, concrete reason why you want to go with A.
Well,
you feel strongly
you
about it,
seem
I'm
to
trying to
be,
give you an
you
opportunity
seem
to
to be-
tell me why.
You seem to be confounding I don't know if I'd characterize it as recommendation. I don't think it's going to make any difference with respect to speed, how quickly we get out a curtailment notice, whether you adopt A or B. We're going to get out a curtailment notice. The only question is, when the person gets a curtailment notice, how effective do they really feel that notice is? And in all honesty, 90% of the people, especially the larger ones, they're lawful and they'll curtail if they get told to do so. This is not an issue of, from my perspective, it's really comes to the question of if we are curtailing people, is there any compelling reason to treat a post-1914 appropriator differently than a pre-1914 appropriator? From our perspective legally, there isn't a compelling reason to say, oh, this one needs to be treated differently than that one. That's the legal answer.
Right.
Now, the public policy issue is that the water community feels quite differently about that. And so to what extent would the water board like to be responsive to those, those impressions, those feelings that they have about the pre-1914 versus riparian? But if we feel like there's a strong need to get out a notice, it'll go out just as quickly under one method versus the other.
Right.
So
Well-
it's not a speed issue, and like I say, I expect that people will comply. So
So too.
it's only this question of the laws says that if we're going to do it, that all parties should probably be treated equally versus people's perceptions. And since I don't see physically it'll make a lot of difference, I personally don't have a strong feeling about how the water board ought to go. If the water board members are comfortable with alternative B, then sure, let's vote for it. You should vote for it.
And I would just like to say that personally, I'd like to see how things sort of play out under different approaches. And so under B, we'd have this new process. And certainly, staff is going to be moving forward quickly on that because you already have the information. You've already begun the process with the original notices. And I suspect that under B, I see some shaking of heads. Whether or not you're ready to roll.
Oh, I just wanted to follow up. This is Yvonne West from the Office of Enforcement. There was a lot of questions about, traditional enforcement or enforcement under the regulation and curtailment. And I just wanted to kind of just take it back, and I'm following up on what Tom just said. These curtailment decisions are going to happen. We're in the emergency drought situation. And the way that we view it is under the regulation, under the proposed regulation or a proposed regulation, the division has more of an ability to make decisions concerning groups or classes of similarly situated water right diverters, as opposed to under what we're couching the traditional approach is where the curtailment decision is made. Then if it's not complied with, you're dealing with an individual enforcement action against an individual and on an individual basis. Then even once you get through that process and that challenge, that final decision is still only binding on that one individual that was in that enforcement proceeding. So when some of these situations where you talk about responding to a complaint and some of the issues that are being talked about, a lot of that is going to be addressable through our traditional, quote unquote, traditional enforcement process through the authorities that we already have. What is benefited through the emergency regulation process is the ability to take a similarly situated class of diverters, put them all under the same curtailment order or regulation, and they have the opportunity to challenge that curtailment decision by any one of the group or all of the group. Once it is issued and challenged and survived that challenge and goes through this process, once we adopt that curtailment decision based on the process, the procedures, and methodologies outlined in this regulation, it becomes binding on that whole group. And so I just wanted to make that distinction from our perspective, because there is a kind of a blurring of the lines going on, and some of the things being discussed, like complaints. We can handle complaints if it's one diverter versus another, but where this really becomes useful is where you have the water availability issue that is the source of those complaints, and there are classes of rights that are affected by it, and they're all in the same situation. They're the equal footing, and I just wanted to focus on that.
And part of the conversation yesterday, not to take it just to a kind of a, I don't know what the right word is, regular person level, and one of the arguments that kept coming up was people's ability not just to understand, but to challenge the basis for an order. And the broader the grouping, the more diffuse the issue, and people feel like they're caught up in this large, broad, all pre-14s, north of the Delta or upstream of the Delta. That's enormous.
Sure.
And so bringing it to a more specific and granular level is, I think, what people were asking for and what they get under the traditional system. And I think what folks are trying to do, and some of the changes on the petition for reconsideration and the suggestions about grouping, is to get that intelligibility of why we're doing something where in a certain place. And I think part of the targeting is to try to target it so the target doesn't end up being so huge as to not really be targeted.
Sure, and I guess my point is that from a process, I feel like we're putting that process, when you go under the emergency regulation, anytime this decision is made, it's not going to be made lightly, and it's going to have to be legally substantiated. You have to be able to support it. And so there's a lot of work that goes into those decisions. And with the emergency regulation and the process that's outlined, that information and the refining that's going on is the intent is to put that information out there so that that class or group of diverters has it before them, and they have that opportunity to question, ask questions, and notice an opportunity to challenge prior to enforcement. Whereas if you're talking about an issue maybe under the more traditional, where you are still trying to regulate a large group of folks that are in a similar basis, in a similar watershed, and I understand the need to refine the analysis to specific watershed or specific groups of rights holders, you're left in a situation where you're doing a lot of after the fact individual enforcement, and then there's still a disbelief whether or not it's going to be enforceable. And then once you do prove it's enforceable, it's just not tailored to an emergency situation. It's just the process wasn't envisioned for an emergency situation. It doesn't offer any immediate mechanism for relief for the state board, and it just, given the time constraints, switching that discussion to before instead of after, I think is valuable, and that's where this type of mechanism could be used most effectively, not in a situation where we could otherwise bring an unauthorized diversion claim.
My only comment, and I totally hear what you've said, and if all we were concerned about was enforcement, there wouldn't be a question here. But what we talked about yesterday, how we got to option A and B, or 2 and 3, is the question of trust. Right now, a lot, and Felicia just mentioned it, a lot of people just aren't accustomed to our being, working with taking off after riparians and pre-14s. They're just simply not used to it. And while we know we would be so careful and so clear and so everything, not everyone thinks we will be. And so that's how we got here. It wasn't that we thought it was a more efficient or even a more effective process from an enforcement perspective, because in fact I think it's not. I think we will get the notices out, but I think actually following up on them is going to be really hard. But if people actually provide us information because there's, and work with us, let's see if what we can get from that. Sure. So that, I just wanted to, let you know that it's not that we don't understand what you're saying, because at least I do, for sure.
Well, and I appreciate what you just said, and I feel that under B, it will give us an opportunity to see how both processes play out. And we do keep hearing it's just really not workable. Not workable if we sent a lot of notices out, but if we did targeted, let's see how much time did it take, how did the process play out, and then we'll hear back from staff. Hopefully we will not be here next year talking about this all over again, but if we are, we will have a lot more information about the failings of classic curtailment. And as you say, we gave it a shot, the whole issue of trust. Then we'll deal with it at that point.
So,
I am now the
improve upon
trust
it.
board member.
so
I would
Totally
like-
messing up my wing theory.
I would like to see the language that staff is crafting with respect to my request for some kind of a process to look ahead. And then with that, I'm very comfortable with the staff recommended changes, especially with option B. And so let's see your language.
If we could have, there's a couple of other changes that we are just making to what we had proposed this morning. If you could pull up the change sheet again, change sheet 1, Janine, to the data relied upon. We're making some refinements to that, but we would like a recess so that we can come back to you with everything that you can.
Why don't we take a 10-minute recess, but try and keep it to 10 or 12, depending on what, 10, 12. We'll come back at 25 after. It depends on which clock.
Do you need less time than that?
Do you need more than that?
No, less.
What do you need?
About 3:30.
Okay, we'll come back at 3:30, but we still need to talk about health and safety.
Yes.
Okay,
Just for scheduling purposes, I do need to leave at 4 o'clock.
right.
We do have the language that you were just referencing, Ms.
Huh?
Doda, that we could put that up.
Can you
Please.
put that up so we can look at it while
Yes.
they're looking on other things, and
Yes.
it'll be up, people can look at it, and then we'll take a break till 3:30? I want to read some of these other things that came in.
And I will just say, while this language comes up, as indicated in some of the discussions earlier, this is modified off of some language that had been circulated and is actually already posted up on the board's website under the comment letters from David Guy at the Northern California Water Association. And primarily, this is something that would go into the resolution under option B, and it is designed to build a process by which we can learn lessons from this year and compare what we've seen this year to 78, with the goal of informing the board going forward in future dry years, how
Right.
to be prepared and what we need to do to not only build up our databases so we can respond, but also which activities have been most effective.
Okay, good.
Thank you.
I'm gonna leave you know, I have to take this off because everybody can hear me muttering now. We're on break.
That's what this break is for.